Today's topic on Legal Talk on eRadio with Hahn and Hahn attorneys is the following, and it's something that we see every single day, especially here at the coast, but I'm sure it's a nationwide situation as well, where you move into a complex and your pets aren't welcome. We saw that during the lockdown as well. What do? I mean, you can't just give away your pet that you love and you've been with for so many years. So what do? That's the big question today. And what can you do legally, I suppose? We are going to ask Wynand Pieterse from Hahn and Hahn Attorneys. He's an associate attorney at the firm. Wynand, nice to chat to you again. How's it going?
Good and you, Ian. How's stuff there along the coast?
Lekker, dit gaan goed, dankie man. En dit raak al hoe warmer hierso. Lyk my die somer is nou hierso.
Ja, nee.
So, Wynand, let's start off with a sectional title scheme or a homeowners association. Do we find these in complexes?
So, yes, Ian. So, when we talk about complexes and apartments, it is important for any existing owner or tenant to establish whether he or she will reside in a sectional title scheme or a homeowners association. So a homeowners association normally govern freestanding estate houses rather than apartments, and so are perhaps more likely to be pet-friendly than sectional title schemes. But again, you should always check the complex's rules before you buy or decide to rent. In most cases, residential complexes are bound and governed by the Sectional Title Schemes Management Act. Further to this, the municipal bylaws will also apply, and it is generally a good idea to have an understanding of both before deciding to rent or buy in a given complex.
Okay, so there's a lot of reading and research that you need to do before you buy. I mean, if you buy first and then read afterwards, I mean, that's not the way it should happen, because then you set yourself up for a lot of problems. So read in advance, do your homework. I can't stress that enough. Otherwise, you are just heading in the direction of heartache and heartbreak. I mean, we cannot part with our pets. They're our children. But let's ask you the next one, Wynand. Any certain rules already in place governing pet ownership in complexes? I would imagine so, yes?
Yes, definitely. So when it comes to pet ownership in complexes, the body corporate may impose limits on pet ownership by either prohibiting pets altogether or impose a limit on the number or type of breeds or sizes allowed, or the access to the common areas with your pets, or noise control, and so on. So the Sectional Title Schemes Management Act has prescribed management and conduct rules which will generally apply by default should the specific complex not have incorporated rules governing the said complex and or amend the prescribed conduct rules. So generally speaking, Section 10 of the Sectional Title Schemes Management Act states that the management of conduct rules must be reasonable and apply equally to all owners of units. And furthermore, the body corporate must keep a copy of all the rules, have the rules available for inspection at meetings of trustees and owners, deliver a copy of the rules to each person who becomes an owner or occupier, and then lastly, deliver to all owners a copy of any rules substituted, added, or amended, and details of any rules that has been repealed. So in addition to what is stated in the Act, the prescribed conduct rules as they relate to the keeping of the animals, reptiles, and birds, as we said, which are prescribed in terms of the Act as it stands, if there is no amended rules that the complex implemented, is the following, and I quote, that the owner or occupier of a section must not, without the trustee's written consent, which must not be unreasonably withheld, keep an animal, reptile, or bird in a section or on the common property. Secondly, an owner or occupier suffering from a disability and who reasonably requires a guide, hearing, or assistance dog must be considered to have the trustee's consent to keep that animal in a section and to accompany it on the common property. Thirdly, the trustees may provide for any reasonable condition in regard to the keeping of an animal, reptile, or bird in a section or on the common property. And then lastly, the trustees may withdraw any consent if the owner or occupier of a section breaches any condition imposed.
Okay, so Wynand, how must these rules be applied and interpreted?
So it is clear from the reading of these conduct rules that the default position is that an owner or occupier may not keep pets when living in a sectional title scheme residence. That's mostly then complexes or apartments. However, the rules further states that the trustees may not unreasonably withhold their approval if an owner or tenant applies to them for permission to keep a pet, although they can impose conditions under which that pet must be kept and can change their minds if these are not met. Owners or tenants who think that the trustees of the body corporate have unreasonably withheld their consent may apply for a declaratory order that the trustee's consent has been unreasonably withheld. This is exactly what happened in a court case. In this case, a woman was refused permission to keep her dog in her flat, and she challenged the trustee's refusal by taking them to court. The court held that each request for permission to keep an animal had to be considered on its own merits, and the decision of the trustees had to be based on the facts and circumstances relevant to the particular case. The restriction on the keeping of animals was designed to avoid the causing of a nuisance to the other occupants of the building, and the fact that permission was refused, despite the fact that the woman's dog did not bark and was never allowed to roam on the common property, meant that the trustees had not adequately applied their minds to the matter. In the end, the court substituted the trustee's decision with its own and allowed the woman to keep her pet. Therefore, if the trustees decide to allow a particular owner or occupier to keep a pet, they are entitled to impose reasonable conditions attaching to the consent. Reasonable conditions could include a requirement that the owner must clean up after their pet immediately if it messes on the common property, and that the pet may not cause a nuisance to other owners or occupiers. If, however, any reasonable condition is breached, the trustees will then be entitled to withdraw their consent, and the owner or tenant may be forced to remove the pet from the complex.
Yeah, I mean, pets can cause a lot of drama, and neighbors, I know people who don't speak to each other anymore because of their pets and the drama that it created between them. Wynand,
Exactly.
what is the test for reasonableness?
So the test to determine whether a rule is reasonable or unreasonable is objective. A South African professor, Van der Merwe, a leading academic on sectional titles, had the following to say in this regard, and I quote, he said, "A rule containing a blanket prohibition on the keeping of animals is unreasonable and therefore invalid because it firstly does not provide a mechanism for the body corporate to consider the individual circumstances of each owner or animal. Secondly, unreasonably and unnecessarily precludes the exercise of the ownership rights of use and enjoyment in accordance with the contemporary standards, which include the entitlement to keep a pet. And lastly, does not permit a balanced consideration of the multiple sides to the issue, but operates only in the interest of sectional owners who oppose pet ownership." Close quote. So furthermore, the Sectional Title Act stipulates that the owner of a unit in a sectional title scheme acquires separate ownership in his or her unit, which entitles him or her to enjoy and use it by exercising the ordinary incidence of ownership to the extent which he or she is constrained in law to do so. The keeping of a pet is a good example of an incident of ownership which entitles an owner to enjoy and use his or her property. This right of an owner will only be limited if the animal causes a nuisance or a hazard to other residents. In normal circumstances, there will be conduct rules that will apply to incidents of nuisance and harm to other residents.
Wynand, what now? What do we do if a dispute arises?
So if some sort of dispute may arise between a tenant or owner and the body corporate, or at the homeowners association, you should first attempt to chat over a friendly cup of coffee to find common ground and a win-win outcome for everyone. Should this, however, fail, the Community Schemes Ombud Service provides an alternative dispute resolution service designed to assist with just this sort of situation. One can furthermore approach the court as a last resort should the Community Schemes Ombud Service not rule in one's favor or its ruling is subject to review.
Okay, so in closing, what are the concluding guidelines that a prospective tenant or owner must take cognizance of?
In conclusion, the following guidelines should be taken into consideration by any tenant or owner wanting to move into a complex. Firstly, if a complex has a notice board at its gate proclaiming that animals are prohibited, or if the rules of the complex prohibits the keeping of animals, no one with pets should move there or buy a unit there. Secondly, before renting or buying in a complex, always ask to be shown the rules governing the complex. Thirdly, it should be noted that if the complex permitted the keeping of pets when you moved in, you cannot be forced to remove your pet should the rules be changed to prohibit the keeping of pets. There is no blanket precedent ruling with regard to nuisance animals. Determine in advance what nuisance means in a certain complex before you commit yourself to moving there. And then lastly, if you are a tenant, your lease agreement cannot conflict with the rules governing the specific complex.
And once again, I have to reiterate, do your homework. Very, very important.
Exactly, that's very important.
Yeah, otherwise you end up with a lot of drama that you just don't need in your life, right?
That's exactly that.
Wynand, thank you so much. That's another legal talk for another week. And you are, of course, at Hahn and Hahn Attorneys. You're an associate attorney. And people can call Hahn and Hahn on 012-431-2480 or check out the website hahnlaw.co.za. All the social media pages. Find Hahn and Hahn on Facebook and also LinkedIn. And you're also on LinkedIn, Wynand?
That's correct, yes.
Okay, fantastic. Well, thank you, and until next time.
Thanks, Ian. Until next time.
Are you or your business in trouble and struggling to find a solution? Call Hahn and Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn and Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn and Hahn Attorneys, Wednesday mornings at 10 on eRadio.